The Supreme Court of the United States has now handed down a ruling in one of the most hotly anticipated decisions of this term, a case known as Moore v. Harper. Its case involves questions related to the Elections Clause, or more particularly, the Electors Clause. And after the ruling came down, a 6-3 decision, many judicial conservatives and conservatives in general were bitterly disappointed with how the court ruled. And I'm not going to lie, I'm one of them. But my unhappiness with the ruling stems from a lot of different things, more particularly the fact that I'm not even sure the court, number one, should have ruled on this, and number two, the ruling that they did give, I don't know really answers any questions. What am I talking about? Hang on, folks, we're going to explain all of that in just 1 second. My name is Brian Trippett. I am your front porch conservative. Step on up to my electronic front porch and let's talk. So as I said, the Supreme Court handed down one of its biggest decisions of this term, Moore versus Harper, a case that involves two particular things and an interesting theory. It involves the question of the Elections Clause and the Electors Clause of the United States Constitution. Now, if you're not familiar with what those are, let me show you first the Elections Clause. This is Article 1, Section 4 of the United States Constitution. The times, places, and manner of holding elections for senators and representatives shall be prescribed in each state by the legislature thereof. But the Congress may at any time by law make or alter such regulations except as to the places of choosing senators. Now, that is the Elections Clause. Now, let's get to the Electors Clause. And that is Article 2, Section 1, Clause 2. Let me find it here real fast. Here we are. Article 2, Clause 2 reads as follows. Each state shall appoint in a manner as the legislature thereof may direct, a number of electors equal to the whole number of senators and representatives to which the state may be entitled in the Congress. Okay, now, that's the Elections and the Electors Clause. The theory that is contested in Moore versus Harper is what's called the independent state legislature theory, and the theory goes like this. Basically, because of the plain reading of those two provisions of the Constitution that I just recited, that the sole authority to determine how things go with relation to a federal election rests in the hands of the state legislature, not the courts. In other words, that power is almost completely without question. Or I should say, in the opinion of those that believe in the independent state legislative theory, that power is unquestionable. Okay, well, that sets up the clauses and the theory. Now let's get to the case. In North Carolina, a Republican state legislature redrew their congressional district maps to, favor the party in power, as you might expect. It's not unusual. Democrats sued. A state court held, no, courts don't have the authority to interfere in this matter. The legislature reigns supreme. Democrats appealed it up to the state Supreme Court, which at the time had a majority of Democrats on the state Supreme Court. The state Supreme Court ruled in what came to be known as Moore versus Harper number 1, that the lower court's decision saying that the legislature has complete, sole, final, and absolute authority to draw their legislative districts in any manner that they so choose is invalid. Go back, redraw your districts. Well, consequently, the 2022 election rolls along, and the Republicans pick up the majority in the state Supreme Court. Well, the decision of Moore v. Harper number 1 is appealed back to the state Supreme Court, and with a Republican majority, they affirm what the lower court ruled, and that is the legislature reigns supreme in this matter. But in the interim between the ruling in Harper number 1 versus Harper number 2, the matter was taken up by the United States Supreme Court, and that gets us to what happens next. So hang on, we're going to get into all that in just one moment. Now, we've established what the particulars are of the case. We've established the history behind it and how it is that this thing is wound up at the Supreme Court. I said at the very beginning of this video that as far as I was concerned, I'm not sure the court ever should have ruled on this, and frankly, now having ruled on it, I'm not sure that the ruling really changes much of anything or really gives any clear guidance. So let me explain why I say all that when we start getting into the article that sort of details what exactly happened. This is from Breitbart.com in an article written by Ken Klukowski, who used to work at the White House and the Department of Justice. Headline: State Supreme Court leaves unclear limits on state court review of state legislature redrawing congressional districts. Wow, that's a mouthful. I don't know who the editor was that came up with that headline, but somebody needs to be talked to. Anyway, state courts can override state legislatures on congressional redistricting maps, but only to a limited extent, and federal courts can override both. A divided U.S. Supreme Court held on Tuesday in a 6-3 decision that could lead to great confusion in coming years in an area where many Americans might want clarity instead. Now, the next couple of paragraphs explains everything I've already talked about as far as the background on this, how the Republican legislature redrew their maps, case was appealed up to the Supreme Court, ultimately got appealed to the U.S. Supreme Court. So what they're ruling on in this is Harper number 1. Now, that said, the majority went like this. 6-3 majority. The three liberals, as you might expect, Sotomayor, Kagan, and Ketanji Jackson Brown, all ruled together, but they were joined by three of the conservatives, Barrett, Kavanaugh, and Roberts, who ultimately wrote the majority opinion. This was a surprise to a lot of court watchers. They were expecting, given the numbers on the court and the ideological makeup, at minimum a 5-4 decision in favor of the state legislature of North Carolina, but they didn't get that. Now, I said the first problem I have with this is the fact that I'm not so sure the court ever should have even ruled on it. Let me get into this article and then show you the text of the ruling, or at least part of it, and you'll begin to understand why I'm saying I'm not so sure they ever should have even touched this. So, going to part of John Roberts' ruling, he says the following: We decide today whether legislatures with authority to set rules governing federal elections free from restrictions imposed under state law. But first the court needed to address the elephant in the room that the case appeared to have become moot. Now, for those of you not familiar with the mootness doctrine, it basically is the constitutional requirement ensures that the parties before us, the U.S. Supreme Court, retain a personal stake in the litigation, Roberts explained, an interest, quote, at all stages of review, not merely at the time the complaint is filed. The majority held that the case was not moot in a nuanced line of reasoning that was emphatically rejected by the three most conservative justices on the court, then turned to the merits of the case. Okay, let me explain mootness for a second. For those of you familiar with the word, if you say, well, the point is moot, that means basically, well, who cares? I don't really care whether you're yay or nay on this thing. It doesn't matter. And that legally is what mootness means. It doesn't matter what we decide. Nobody's affected by the decision. So in order for the court to issue a decision on this, they had to get past the question of mootness. Because remember what I said a little earlier. There were two Harper rulings. The original ruling, which was by the Democrat-controlled state Supreme Court in North Carolina, said, no, these district maps must be redrawn. Then Harper number 2, which was ruled under by a Republican majority on the North Carolina State Supreme Court, that said, no, the legislature's perfectly fine. They have ruled on this matter. It's done. It's over with. Now, The three conservatives who dissent, which would be Alito, Thomas, and Gorsuch, said, well, this case is moot. Harper number 2 means that the matter is done and settled. Nobody's got a dog in this hunt anymore. The thing is over with. Now, here's what Roberts did to allow the majority to be able to give the ruling that they did. I want to go for just a moment to the text of the Moore versus Harper decision that the Supreme Court handed down. Take a look at this. Now, I'm going to read through parts of this. I won't read all of it because it's legalese and, I can't stand that much of it. But Roberts basically gives himself the wiggle room to be able to rule on this. And personally, I'm of the opinion he wanted to rule on this. He didn't want this thing to get kicked back to North Carolina. He wanted to address the question of independent state legislature theory. So that said, that sets up the threading of the needle that we're about to read about. Before turning to the merits, we must determine, and this is again from the decision issued, we must determine as a threshold matter that we have jurisdiction. The Constitution provides our jurisdiction over cases and controversies. Mootness doctrine addresses whether an intervening circumstance has deprived the plaintiff of a personal stake in the outcome of the lawsuit. Translation, has some event happened that basically means, well, it doesn't really matter how we rule, it's over with anyway, before we've ever handed down a decision. Now, here's where he starts threading the needle. The North Carolina State Supreme Court decision to withdraw Harper 2 and overrule Harper 1 does not moot this case. The plaintiffs here sought to enjoin the use of the 2021 plans enacted by legislative defendants. Harper 1 granted that relief. Now, we go a little further into this. Here's where he starts threading the needle. Watch this. But although the defendants may now draw the new congressional maps, in other words, the North Carolina State Legislature, they agree that the North Carolina Supreme Court overruled only the reasoning of Harper 1 and did not, quote, disturb its judgment nor alter the presently operative statutes of North Carolina. The North Carolina Supreme Court has done nothing to alter the effects of the judgment in Harper number 1 in joining the use of the 2021 maps. As a result, the legislative defendants' path to complete relief runs through this court. Were we to reverse the judgment of Harper 1, a step not taken by the North Carolina State Supreme Court, the 2021 plans enacted by the legislative defendants would again go into effect. The parties accordingly continue to have a personal stake in the ultimate disposition of the lawsuit. Let me see if I can break this down. Basically, what Roberts does, and I say he threads a needle here, a needle of mootness. Basically, what he's saying is, well, look, yeah, there was Harper number 2, which overturned Harper number 1, but hey, when we got this decision, all Harper number 1 did was just, knock out the reasoning. It didn't knock out the effect, which means somebody in this case is going to get hosed. So, hey, since somebody's got a stake in this thing, we got to rule on it. Even though the Republican-led state Supreme Court settled the matter when they said, no, the lower court, we stand on their decision, we abide by it, we sustain it, the legislative districts go forward. Basically, from my perspective, Roberts pulled a legislative sleight of hand, and he needed to do that in order to be able to hand down the ruling that he did. Now, we're going to address what the three dissenters thought of this whole idea a little bit later, so hang on to all that. Going back to that article from Breitbart, we read the following. Since early in our nation's history, courts have recognized their duty to evaluate constitutionality of legislative acts. The court held that, quote, the Elections Clause does not insulate state legislatures from ordinary exercise of state judicial review. In sum, our precedents have long rejected the view that legislative action under the Elections Clause is purely federal in character, governed only by restraints found in the federal Constitution. The Elections Clause expressly vests power to carry out its provisions in the legislature of each state, a deliberate choice that this court must respect. And Roberts goes on to cite a previous decision back in 2000 in Bush v. Gore. State courts retain their authority, this is Roberts speaking, to apply state constitutional restraints when legislatures act under the power conferred upon them by the Elections Clause, but federal courts must not abandon their own duty to exercise judicial review. In interpreting state law in this area, state courts may not so exceed the boundaries of ordinary judicial review as to unconstitutionally intrude upon the role specifically reserved to state legislatures by Article 1, Section 4 of the Federal Constitution. Basically, what Roberts is saying is, hey, look, just because the state legislature is granted authority under the Elections Clause doesn't mean the state courts don't have the right to review their actions if a case is brought. And not only can the state courts review it, federal courts can review it as well. Okay? Now, I've got any number of problems with this case. But basically, in my book, what Roberts has done here is left the door wide open for a continuance of what we've already been dealing with for the past 20 years, which is election lawfare by the likes of Mark Elias, Eric Holder, and other Democrat operative lawyers around the country who want to go meddling in state legislatures and state legislative district drawing. He hasn't. This decision by the United States Supreme Court solves nothing. All it says is, well, yeah, okay, there's a clause there that says that, these matters are decided by the state legislatures, but still subject to judicial review. Now, that's the majority's. Now, as you might imagine, the three most conservative members of the court, Thomas, Alito, and Gorsuch, were none too happy with the majority in this matter. And Justice Thomas wrote for the dissenters. I want to read in part his dissent dealing with the question of mootness. In other words, how Roberts got around the question of whether the court even ought to be taking up the case. And as you might suspect, as far as Thomas is concerned, the court never should have even addressed this particular case. Not to say they wouldn't be willing to address the issue of independent state legislature theory. It's just that this case, as far as Thomas is concerned, there's no reason for us to even rule on this. So let me show you the text of what he said. Take a look at this. Quote, "Here is the case before us in a nutshell. A small group of plaintiffs, the Democrats, sued various state officials, the Republican legislature, under North Carolina state law. The defendants raised both state law and federal law defenses. In the interlocutory judgment below, the state Supreme Court rejected both defenses and remanded for further proceedings. We granted review to consider the defendant's federal defense." In other words, the state legislature appealed it up to the U.S. Supreme Court. But then, in subsequent proceedings, the state court revisited the defendant's alternative state law defense and held that it was meritorious. As a result, the state Supreme Court finally adjudicated the whole case in the defendant's favor. In other words, the state legislature of North Carolina, dismissing the plaintiff's claims with prejudice. Now here's the next paragraph, and it's the most important. "This is a straightforward case of mootness. The federal defense no longer makes any difference to this case. Whether we agree with the defense, disagree with it, or say nothing at all, the final judgment in this litigation will be exactly the same. The majority does not seriously contest that fact. Even so, it asserts jurisdiction to decide this free-floating defense that affects no live claim for relief, reasoning that a judicial case or controversy exists as long as its opinion can in any way, quote, alter the presently operative statutes of a state. By its own lights, the majority is acting not as an Article III court, but as an ad hoc branch of a state legislature. This is emphatically not our job." Tell you what, say what you want to about Clarence Thomas, but by George, that man can write. Basically, his point is this. It's like, look, the first version of Moore versus Harper, okay, the North Carolina State Supreme Court ruled in favor of the Democrats, okay? The Republican legislature appealed this thing up to us. All right, now in the interim, with a Republican majority on the North Carolina State Supreme Court, the State Supreme Court ruled in favor of the Republican state legislature. Therefore, the whole matter is moot. It doesn't affect us anymore. We've got nothing to decide here. And frankly, for us to start deciding it doesn't mean we're a court anymore. We're starting to be some committee of the state legislature. And I tell you what, as far as I'm concerned, he's absolutely right. The United States Supreme Court, when the second version of Moore versus Harper was decided by the North Carolina State Supreme Court, this matter should have been kicked right back to North Carolina and said, y'all do with this what you want. But it didn't happen that way. So Thomas then goes on to explain why this is a bad decision, laying aside the question of mootness. So let's go back to that Breitbart article, and we read the following. But since the majority addressed the merits of the case, so did Thomas, writing that, quote, a federal function derived from the federal Constitution transcends any limitations sought to be imposed by the people of a state. He quoted previous Supreme Court precedent that held that the Elections Clause is the exclusive delegation of such power as no other constitutional provision gives states authority over congressional elections. The Elections Clause is not referring to state courts, Thomas wrote, because legislature in the Constitution generally means the representative body which makes the laws of the people. In prescribing the times, places, and manners of congressional elections, the lawmaking body or power of the state, as established by the state constitution, performs a federal function derived from the federal Constitution, which thus transcends any limitations sought to be imposed by the people of a state. The majority opinion ends with some general advice to state and lower federal courts on how to exercise judicial review in cases implicating the Elections Clause, Thomas continues. As the majority offers no clear rationale for its interpretation of the clause, it's impossible to be sure what the consequences of that interpretation will be. Now, there's one last paragraph here, and I will not bother going through it. But basically, Thomas's point is this, look, you members of the majority, you've decided this thing, but you haven't really decided anything. You've given no clear guidance for what state courts are supposed to do or what lower federal courts are supposed to do. And that is my problem with this decision, laying aside the issue of the fact the Supreme Court never even should have been ruling on it after what the second Moore v. Harper decision came down. There's nothing here that gives anybody any kind of definitive path going forward to settle these issues, which means that for the past 20 years, we've been dealing with election lawfare, as I said a moment ago. We're still going to be dealing with this. The United States Supreme Court, if not with this case, then with some case down the line, and it's going to happen sooner or later, is going to revisit this issue. And when it does, the United States Supreme Court needs to decide once and for all who has the authority over federal elections. Is it state legislatures, which is what the Constitution says, or is it state courts or commissions or things not prescribed in the United States Constitution? It's a very interesting case, and one that's going to be brought back to the Supreme Court somewhere down the line. But that's what I think about the whole thing. What do you think? As we start to wrap this up, please do me some favors as always. Number one, if you're not a subscriber to this channel, please do so. Number two, please leave a comment below. I'd really appreciate to know what you're thinking about all these videos. Number three, share it around to friends of yours. Number four, give me a thumbs up. And number five, help me out wherever you can. I'll take every piece of help I can get. My name is Brian Trippett. I am your Front Porch Conservative, and I'll see you next time.